To part 2 of the Thursday edition of The Attitude. And of course, if it's Thursday and it's the fourth Thursday of the month, it must be what? It must be race class. We're up to episode number 32. Race class. And the reason we created it was because legislation restricting the teaching of race and racism in public schools and government entities has spread across the country. In an effort to respond to this, 3 years ago, BU law professor Jonathan Feingold and Arnie Arneson of The Attitude decided to start offering something we call race class. We offer it once a month. It is a course conversation where listeners can hear what it's like to approach race and racism from a place of curiosity and history, rather than fear and anxiety. And in describing the foundational purposes of race class, Jonathan Feingold noted, "We know race matters. Part of this project is to make sense of what that means." So let me welcome Professor Feingold back to the program. Thank you, Jonathan, for doing this and holding my hand for, 3 years. January will be 3 years. It's unbelievable. But you know what? In a lot of ways, with each passing month, the need for this class only increases. You know, I feel like every time I turn around, we need to have more and more of a conversation. We need to know more and more about our history. We need to understand why Donald Trump says, "So when did Kamala Harris become black?" You know, So it is both timely and terribly important. And you sent me an article. I'm not sure whether you have it published yet, but it was entitled "Project 2025's Irony. Even a Trump judge agrees that anti-CRT laws don't ban CRT, critical race theory." So let me welcome you back to the program and explain to us why you wrote this piece and what inspired it.
Thanks, Arnie. Always really nice to be with you. I'm going to take a very slight detour before we get here, in part because yesterday was the day that the state of Missouri executed, whatever the term we're using, Marcellus Williams, yes. Notwithstanding just massive public advocacy, outcry advocacy to stay this execution. That also came from the local prosecutor's office, also came from the relatives.
Also came from the jurors as well. The jurors that sat on this case, okay? It was like universally sort of disapproved, don't do this.
And then there was essentially an 11th hour last minute appeal up to the U.S. Supreme Court to halt the execution, which was denied. And some of the understandable sort of commentary coming out of it was just this identifying the outsized power that an unelected body of 9 justices, 6 of whom now hold incredibly right-wing, often anti-democratic views, have the ability to determine life or death in this sort of situation, in the most anti-majoritarian sort of way. And that story is partly right. But something that is not being, I think, said is that there's also, or it's probably being said, I just haven't seen it, but I want to note it now, that story, that narrative of this outside power from the Supreme Court undermines or precludes Missouri from halting this execution, suggests that Missouri always listens to the Supreme Court. That anytime the Supreme Court says this is the law or this is the rule, or you have to do X, the state of Missouri says, okay, we'll do X. Exhibit A, in 1945, Missouri adopted a constitution that included a provision that stated, separate schools shall be provided for white and colored children, except in cases otherwise provided by law. So this is mandating a dual de jure segregated educational system. We all know that 9 years later, in 1954, Brown v. Board of Education says that's unlawful. How many years did it take, Arnie, until Missouri altered the language of its state constitution?
I have no idea.
Yeah, I'm 20.
But it took 20 years for them to alter the language of their state constitution. But that doesn't mean that they don't follow the Supreme Court decision. I mean,
except they also were not in many cases. So also not simply leaving language on the books, but also in different sorts of ways, obstructing the transformation of an educational system that is segregated to one that is integrated. And so just the point is, we have many examples through history in which actors in the United States, entities in the United States, say no thanks to the Supreme Court. And it's just important to juxtapose that with moments like this so that the narrative is not simply the state of Missouri's hands were tied, given that there have been times in the past when the state of Missouri did not fall in lockstep with what the Supreme Court said. It is just meant to be an observation.
Well, let me just say something. I posted the last statement of Marcellus Williams, and this is the last statement he made before he died. All praise be to Allah in every situation. 3 exclamation points. That was his last words. Okay, everyone? So I posted this on my Facebook page, Jonathan, but I also made a connection to something that makes me still angry and makes me still cry. Ready? I wrote, no words, just his words. When Jeanne Shaheen was the Democratic governor of New Hampshire, she vetoed the repeal of the death penalty. Send her this. We have now repealed the death penalty, everyone, finally, in the state of New Hampshire. But there is one person still staying on death row, a young black man. The repeal of the death penalty does not apply to him. All right? And the only reason why he is sitting on death row in New Hampshire is because of Jeanne Shaheen's decision to veto the repeal of the death penalty, Jonathan Feingold, by a Republican-controlled legislature. Just think about that. And I want everyone to send her this last statement. I want her not to feel comfortable going to bed at night, because I don't for her. Anyway, I'm glad you brought it up, but it's again, the number of people of color on death row is something that we need to talk about. What just happened where so many people across, to the end, he said, I didn't do this. I didn't do this. And even the prosecutor wanted this. It's just so shocking when there were so many opportunities to not commit murder, but the state committed murder. And that's what it did, Jonathan. Sorry.
So, and this is all against the backdrop where for the past 4 years now, there has been a concerted effort across a network of right-wing politicians, think tanks like the Heritage Foundation, Manhattan Institute, related organizations like ALEC, to prevent students from learning about race and racism in school. Mm-hmm. And the first time do you remember the first conversation we had on this program, what I was talking about, which was before race class?
Okay, this is the one that you wrote the article about that I called you up and then I offered you an opportunity to speak from. I have no memory of that. You'll bet to refresh my recollection.
So in the fall of 2021, I wrote this article where I said, if you read the text of these so-called anti-CRT laws, it turns out they don't ban CRT.
Wow. That was 2021?
It's 2021. It was the fall. It was like December, November 2021. Okay. And I was making this point from the position of a law professor who trains his students to care about legal text. Mm-hmm. On the one hand, of course it was true that these laws, like Florida's Stop Woke Act, like Oklahoma HB 1775, they were designed to delegitimize anti-racism as a sort of as a value, as a commitment, and meant to, I think it's fair to say, purge schools of any meaningful conversation about race or racism, particularly one that took a sort of structural or adopted a structural lens or approach. Now, that was the clear point of those laws, maybe the motive. But again, as a law professor, with students, we looked at the text. And the question is, well, what do these laws actually ban? And so many of these laws, like in Oklahoma, which we'll talk about, they trace to an executive order then President Trump issued in, I think, early September of 2020, that then became the model or blueprint for copycat laws that spread. And it included a list of quote unquote divisive concepts, things that would not be permitted to teach. And stuff like one race or sex is inherently superior to another race or sex, or an individual should be discriminated against or receive adverse treatment solely or partly because of his or her race or sex, and prohibiting race and sex stereotyping and race or sex scapegoating. Now, if you're a Martian and you just land and you see this, these sorts of prohibitions, it probably strikes you as rather innocuous. Sure, like schools should not be teaching students that they should be stereotyping and that they should be scapegoating, or that any racial group is inherently superior to one or another. Because in the abstract, out of context, that's how you would read it. Mm-hmm. But these provisions, they mapped onto the rhetoric of folks like Chris Rufo and everyone else who is just rehearsing these anti-CRT caricatures, because they were all meant to caricature, again, anti-racism and CRT. And I think there's probably good evidence that on the campaign trail, in social media, just trading in or trafficking in caricature and distortion actually, can play well. It can get you what you want. But when you then codify the caricature into law, you're not banning the thing you're caricaturing. You're banning the caricature. And so this was, in a sense, the argument that I was making, that if you take seriously those words, those provisions, and transpose that on an accurate understanding of what something like critical race theory is, then it's not banning it. In many cases, it's actually encouraging, permitting, maybe even requiring teachers to teach about stuff like implicit biases or structural racism.
And the judge in Oklahoma, I believe, agrees with you, because as I'm reading your opinion piece, I mean, everyone, I'm listening to you. That's right. You're banning the caricature. Well, that's good, because it was never true in the first place. So what you're banning is something that was never true in the first place. So then the question is, if that's what you're focusing on, then I think what you pointed out with what the judge did in Oklahoma is that when one digs into his analysis, the opinion reads like a stinging defeat for those set on purging conversations about racism in Oklahoma schools. So explain to us, what did this judge actually find, which I think is making your point that you were trying to make in 2021?
Yeah, so I'll take a couple half steps back to set this up for everyone. So in 2021, Oklahoma became the second state to adopt one of these so-called divisive concept laws that nearly everyone in the country who was talking about this described as a CRT ban. And that's understandable, in part because the way that its proponents were talking about it would make it seem like it was designed to and would effectively ban critical race theory. So the lead sponsor of the bill said that it would, quote unquote, end the requirements for race-based bias curriculum, is how they put it. And after its passage, publicly, it was sort of understood to do these things. So you had a community college in Oklahoma City that canceled summer classes on race just because they were about race. You then had state officials invoke the law to justify downgrading the accreditation of Tulsa Public Schools, which is the state's largest district and serves almost 80% students of color. And the rationale, the justification was that the district had provided us training to employees on implicit bias, which again was the sort of thing that was under attack rhetorically. And so it makes sense that state officials would go after it. But if you look at the law actually supports equipping students and teachers with tools to mitigate biases and stereotypes. And so, but the backdrop is, again, like Florida's Stop Woke Act, like laws in South Carolina and Texas, it was promoted by folks who were actively assaulting through their rhetoric anti-racism and critical race theory, so understood in that way. But the language didn't align with that. And so what you have in Oklahoma is the ACLU, Lawyers Committee for Civil Rights, I believe, and some other civil rights organizations sue to strike down the law on a couple of bases. And there's this either interesting or ironic, or if it's me, it's like, yeah, it's what I've been saying, twist. The judge is this person, Charles Goodwin. I don't know anything about his record as a judge or before. He was a Trump appointee, which tells you at least something about his politics, or likely does. And this Oklahoma law, HB 1775, had 8 divisive concepts that were prohibited, largely mirroring that Trump executive order. 2 do get struck down. And so we should also point out that in New Hampshire, about a month before, a federal judge struck down New Hampshire's entire discriminatory censorship law that had 4 of these provisions on the ground that it was unconstitutionally vague, meaning that teachers just didn't have enough guidance or notice on what was prohibited and what was permitted. And that's the similar sort of argument that has been made in other states. And so Judge Goodwin strikes down 2, but he upholds 6 of the provisions. And this is when, if you are a proponent of discriminatory censorship, you probably think it's a win. But as you said, if you read the opinion, it doesn't look like a win. And so we can get into some of the specifics. So again, this law that is challenged requires or prohibits teachers from requiring or making part of a course these 8 concepts, 6 of which are upheld, including things like any individual should feel discomfort or guilt because of his or her race, or that an individual by virtue of race is inherently racist, consciously or unconsciously. These are the sort of provisions that people have read and then said ban implicit bias, for example, or somehow give white parents a veto to just cancel classroom conversations about race that they happen to dislike. Judge Goodwin just said no. He said that that is wrong.
Right.
And he started by saying,
unbelievable.
Well, if, kudos to him.
Yeah,
he closely read the law, including a provision that expressly protects teaching that aligns with state standards, common to many of these laws. And it makes sense. Whether or not it makes sense, many state standards actually mandate that students learn about race and racism. And through that, Judge Goodwin, again, this Trump appointee, very explicitly states that means that, notwithstanding this law, teachers must still teach about slavery in America and its political and economic consequences, the role of slavery as the principal cause of increased sectional polarization leading to the Civil War, the Tulsa race riot, as it's described, and, among many other things, the effect of past bias and discrimination on current behavior. God. All of that, not only is it in, but teachers have an obligation, professional responsibility, to ensure that students are learning about it. And he goes on, because the ACLU, in their briefing, also articulates the concern that this law, again, like Florida's Stop Woke Act, is going to create this, essentially white parents' veto to prevent topics that make students feel discomfort or distress. And again, kudos to Judge Goodwin. He reads the statute closely. And he says that that is wrong, in part because what the law prohibits is telling a student they should feel guilty or they should feel discomfort, which, like, what teacher does that?
I know.
And so Judge Goodwin, he responds, he says, K through 12 teachers, quote unquote, may and should teach about events that make students uncomfortable. He says, go for it. You want to talk about institutional racism? Go for it. The law, again, according to Judge Goodwin, does not prohibit teaching that an action by a person or an institution is racist, or results in undue oppression, or that inaction by a person or institution in the face of racism is itself racist. Now, the upshot here is that as a formal legal matter, Oklahoma teachers, like teachers in Florida, like teachers in South Carolina, like teachers in Texas, can and indeed should talk about race and racism and concepts like institutional racism. And these laws do not, in fact, give white parents or white students the ability to veto a lesson on the Tulsa Race Massacre or white privilege just because that might make them uncomfortable.
Okay, so Jonathan, I read what you're writing. I understand what the judge said, but let me talk to you about something that's real, and it's called the chilling effect. And unfortunately, they're not going to call the judge. They're not going to bring the decision into their classroom. They're not going to bring the decision maybe before the school board. There's been such a chilling effect that we don't even know what's not being taught because we have self-censored. We are so afraid of drawing attention that, and the self-censoring probably even goes even farther beyond what they thought that they were accomplishing. So I am grateful and I am happy, but you know what? I go back to Amber Thurman, the young woman that died because she couldn't access an abortion in a timely fashion. She couldn't get the health care, actually the health care that she needed. And the problem is they were saying, well, no, actually these doctors could have treated her sooner. But you know what? They were afraid. They didn't know. How close to death is death? How far do you have to be down that toxic anti-healthcare situation where you're on the verge of death, and do you enter in a timely fashion? This has been the idea of the chilling effect is the thing that I think we have to really talk about. They don't care about the legality. They care that they have created the threat.
So we did not talk about this, but I'm so glad this is where you went, because something that I, a conversation that often threads through multiple of my classes is just identifying that space between some right in form, like something that's formally a right, and a right in practice. So we talked about this with respect to the Second Amendment and guns. Like, everyone might have a Second Amendment right, but one's ability to actually enjoy that is deeply dependent on their racial identity. And here, it is true that these laws, as a formal technical matter, do not prohibit all the stuff that we collectively have been saying they do, but that in no way alters the horrifically hostile and toxic environments that teachers in all of these states are confronting. And that begs many additional questions, which is, okay, how is it that even if these teachers, as a legal matter, are permitted to teach this stuff, but the state can, through different means, can just exert so much power,
right,
in a way that it doesn't matter what the law is.
And we just talked about vouchers in the first half of this program today, of race class. And in the first half we were talking, and vouchers is a form of resegregation. And yet we have the idea that it's illegal to use public dollars to educate kids in a segregated manner. Well, guess what? We're now using public dollars to educate kids, and we're getting a segregated result. So, I mean, again, Jonathan, whether it's the state whether it's this creative way of doing an end run around what it is we use our public dollars for. Look at what's happening. Whether it's the chilling effect or the creation of vouchers, we're getting to the opposite of what the law claims to want to basically make illegal.
And so I'll say a couple of things in the minute we have. So the last thing that I mean to do is suggest that because the law, the best reading of the law says one thing, that dictates what the experience is for students and teachers on the ground. Because what we've seen is the opposite of that. I recently was able to sort of preview a new study coming out of Florida, and it is dire what is happening there, and just the professional vulnerabilities, the personal vulnerabilities, economic vulnerabilities that teachers are facing out there. But what I am confident about is that it doesn't help when the narrative overstates the scope of the law, because that enables bad faith actors to
be emboldened,
to be emboldened and to propel this chilling effect. And so, but that does not.
And I need to let you go. We could go on for 2 hours. This is Race Class episode number 32. We've been talking with Boston University law professor Jonathan Feingold.